Good afternoon. My name is Klaus Grabinski. I'm president of the Court of Appeal of the Unified Patent Court, and you are on IP Friday.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 141 of IP Fridays. Today's interview guest is Dr. Klaus Grabinski, who is the presiding judge of the Court of Appeals at the Unified Patent Court. And we talk about the Unified Patent Court system, which launches next Thursday on 1st of June 2023. But before we jump into the interview, I have news for you. The content management system of the Unified Patent Court seems to have problems. It's quite overloaded and it's very difficult to use at the moment. So the Unified Patent Court recognized this problem and now allows hard copies to be filed for opting out patents. So you don't have to use the CMS, the content management system anymore, but actually can file opt-outs, requests for opt-outs on an USB stick. And the details are provided on the website of the Unified Patent Court. This is as of 25th of May, so yesterday. The Industry Patent Quality Charter, which was started by companies such as Siemens and Ericsson and Bayer, has gained a lot of attention in the last days. A lot of news outlets in Germany featured this Industry Patent Quality Charter and citing declining quality of granted patents at the European Patent Office. Emmentaler cheese cannot be trademarked in the European Union as the German public sees it as a type of cheese rather than by its geographical origin, Europe's second top court said on Wednesday, so 2 days ago. Court said, since the mark applied for is descriptive of a type of cheese for the relevant German public and is not perceived as an indication of the geographical origin of the cheese, the General Court concludes that it does not enjoy protection as a collective mark. Now let's jump into the interview with Dr. Klaus Grabinski. Today's interview guest is Dr. Klaus Grabinski. If you don't know Klaus Grabinski, he is the president of the Court of Appeals of the Unified Patent Court. And also he has significantly contributed to the drafting of the rules of the procedure of the Unified Patent Court. And he is also still a patent judge at the Federal Court of Justice in Germany. Thank you very much for being on IP Fridays.
Thank you. It's a bit like coming home. I've been on the program already twice, and it's always a pleasure. Thank you for inviting me.
Thank you for coming back, and I'm very grateful for your valuable time. So I have questions of very different types, and first maybe some administrative issues. You have been deeply involved in creating all the articles and rules that will govern the proceedings before the Unified Patent Court. Are you satisfied with the current proceedings?
Yes, it's true. I've been a member of experts committees that were advising first the European Commission and later the preparatory committee of the UPC. And the larger outline of UPC proceedings is that it is front-loading. So that means that parties are required to put all their arguments, all facts they are relying on, all evidence they are relying on in a written procedure that will be followed by a interim procedure. Main purpose of the interim procedure is to organize, do everything that is necessary so that the oral hearing will not take, at least in an average case, no longer than 1 day. So it should not be like in some common law countries on a regular basis, that oral hearings take several days, even several weeks sometimes. And in that regard, I'm regarding that structure of the proceedings, I'm satisfied, yes.
And that is quite something that hits the eye if you see the judges. On the other hand, the rules have been also influenced by the British legislation and the case law of the UK. And the UK is no longer part of the Unified Patent System. As it was with the case law of the European Patent, the EPC, I mean, the early decisions will probably lay the groundwork for the future case law. So will the early decision remind us more of German case law, of British case law, of French case law, the Dutch case law, or do you think it will be mostly governed by the case law of the Boards of Appeal of the European Patent System? What do you think?
I think we have to distinguish between substantive law and procedural law. Regarding substantive law, there is already a lot of harmonization in Europe on the national level, and I expect the UPC to build on this case law. Regarding procedural law, the procedure is to some extent new. It's different from the national procedures, and in that regard, I expect the UPC to give its own interpretation and to develop, of course, its own case law. And that, of course, there are some issues where you have, particularly also in the substantive law, where the national courts have different views, and then it will be interesting to see which way the UPC will go. And then, of course, there are also issues concerning substantive law where there's no case law at the moment, new developments, and then again it will be interesting to see where the UPC will go. But don't forget, most of the judges are experienced judges from the national jurisdictions. So it's not going to be we're not going to be completely new from scratch.
I also don't expect big surprises. Some technical judges are practicing patent attorneys in patent law firms, and some of them have left their jobs in the patent law firms to avoid a conflict of interest or the problem of impartiality, and some did not. Will you or your colleagues offer some guidance how to address this?
Well, the issue of impartiality of judges, conflict of interest in particular, is dealt with in principle by Article 17 of the UPC agreement and by Article 7 of the UPC statute. However, also the service regulations adopted by the administrative committee provide in Article 7 that a code of conduct shall be adopted by the administrative committee, but shall be prepared by the advisory committee in cooperation with the presidium. And that procedure is work in progress at the moment. So it can be expected that a code of conduct will be adopted by the administrative committee before the system will be up and running on 1st of June this year.
That is very, very helpful information. Thank you. So one other question that I got from small clients, some are very small entrepreneurs who often, after long consideration, apply for maybe only one patent, European patent. And after the transition period, as is well known, only the Unified Patent Court will be responsible, whose cost structure might be much higher compared to a German infringement court, especially maybe the refundable costs when the losing party has to pay. And is it to be expected that some of these small entities maybe will simply not be able to afford the patent system or the new unified patent court system, or will there be maybe a small entity status like in the US with respect to the court fees, or what will be your recommendation for the small, very small applicants or patent owners? Would it be possible to introduce a new small entity status in the future, maybe?
Well, when we talk about costs of procedure, you first, of course, have to know that in Europe we have the cost shift system. So meaning the loser has to compensate the winning party for recoverable costs, and this essentially concerns court fees on the one hand, and on the other hand, representation costs. So regarding court fees, I'm not sure whether the UPC is really more expensive than national court systems where at the moment cases are brought to. To my information, most cases at the moment are brought before German courts, but of course also to other countries. But when you now compare it to the court fees of the UPC with the court fees of the German courts, you will notice that when you take the same value of litigation as basis, as it's provided for in both systems, and that the court fees of the UPC are generally lower than the court fees that have to be paid before German courts regarding infringement as well as revocation actions. Concerning the issue of small enterprises and even micro enterprises, I also like to draw your attention to a provision in the rules of procedure dealing with court fees that is saying that these parties they can require to pay only 60% of the court fees, so even less than the already comparatively, at least when you compare to the German system, low court fees before the UPC. Another aspect, of course, is the recoverable cost of representation. And in that regard, when again I compare it to the German system, in the German system, depending on the value of litigation, a fixed amount of money has to be paid as a recoverable representation cost by the losing party to the winning party. In the UPC system, it is not, it's again based on the value of litigation, but it is not a fixed sum, it is a ceiling. And so it means that it will not go higher than the ceiling, but of course, the cost decision can be below the ceiling and much below the ceiling, depending on the costs that were made and were appropriate, of course. And when you now compare the fixed amount, same value of litigation in the German system with the ceiling in the UPC system, you will see that the ceiling is higher, significantly higher than the fixed amount in the German system. But again, it is a ceiling, and I don't think in all cases costs will recoverable costs will end up at the ceiling, at the level of ceiling. But details will still have to be developed by the court.
We will have to see. That's right. Or maybe it is not much more expensive than in Germany. Let's see how this will develop. The central divisions are mostly in charge of the isolated revocation actions and the actions for declaration of non-infringement. How busy do you expect the central divisions to be in comparison with the local divisions such as Düsseldorf and Munich?
Well, that's difficult to say because it largely depends on where the cases will be brought, and that is for the users to decide and not for the court to decide. So I'm also a bit excited to learn how many cases will be brought to the UPC from 1st of June and where they will go. So, sorry, I can't give a prediction in that regard.
Right. We all don't know yet how the users will use the system. You are not the user, you are the service provider, basically. You can't really tell.
Exactly.
Right. So maybe a similar question, but how many appeal proceedings in progress under Rule 222 and 3 do you expect? Will this be a frequent case or will this be the typical case in your opinion?
Well, it depends on whether the user make use of these provisions, which in particular Rule 220 paragraph 3 deal with the so-called procedural appeal, meaning that also appeal can be filed against procedural decisions of the court of first instance. And can be brought to the Court of Appeal if leave was granted by the Court of First Instance, and if not, then still the party can bring file a so-called discretionary request for discretionary review. And when then the standing judge allows the review, then again this issue will be brought before the Court of Appeal. So we will see to what extent parties will make use of this instrument.
Yes, let's see. I also have some questions regarding the interpretation of the law. We all don't know how the court will decide, but there is case law in all the nations currently, for example, by the Federal Court of Justice in Germany, where you are part of. And there is case law of the Boards of Appeal of the European Patent Office. And in theory, the discrepancy is resolved in theory by the rules, but how do you think this will work out, like with regard especially on claim interpretation?
Well, a claim interpretation or claim construction, I think the approach in general is the same all over Europe. It is clear the description and the drawings have to be taken into consideration when giving interpretation to the claims. It is clear the perspective is a technical perspective, it's not purely a linguistic perspective. So I think there is not, there's quite some harmonization already there, and I'm confident that the UPC will build on that approach and will not differ much from what is already has been decided by the courts of the contracting member states.
Yes, and I have one very specific question in this direction. Will the UPC apply the problem solution approach of the Boards of Appeal, or will it go more like have the interpretation of the national courts?
Well, I think the perspective is probably a slightly different perspective of the EPO as a patent office, and of course also the Boards of Appeal that are to some extent designing the case, the approach then put into practice by the examiners, and the courts on the other hand, so court litigation. The situation in prosecution is there's the examiner that has to make his research and then in contact with the applicant decide on the patentability of the patent. In that regard, I understand that should be a very well formulated, defined approach, which is called the problem solution approach, developed essentially by the boards of appeal. In court litigation, patent court litigation, it is a different situation. Usually, the claimant submits certain lines of argumentation. Why, for example, the invention as laid down in the claim was obvious to the person skilled in the art. For example, combining prior art A with prior art B, prior art A with prior art C, and B with C, for example, and then giving arguments why it was obvious. Then, of course, defendant the other way around gives patent owner gives arguments why it was not obvious, and then it is for the court to have a look at this and decide who is right and who is wrong. So that's a different approach, and I guess the UPC will more build on the approach that is already applied by the national courts of the contracting member states, rather than the approach that is practiced by the EPO. But of course, there are a lot of overlap in that regard, so it's not completely different.
I agree. It's nearly identical, but there are subtle differences. At least some people think there are. So let's see how this will work out. And I agree, you are dependent on the arguments brought forward in the court, and not on any structure that was given by the boards of appeal, of course. So I have a question regarding the future of the national patent infringement courts. Where do you see the future of the national patent infringement courts in, let's say, 5 or 10 years? How do you think this will develop?
Well, during the first 7 years, so the so-called transitional period, parties can bring litigation to with regards to classical European patents in parallel to the national court or to the UPC. So they can decide. So that will, I guess, also mean a lot of work for the national courts. Then you have the opted out European patents that can only be litigated before the national courts. That's again a lot of work, I guess, for the national courts, or leave a lot of work for the national courts. And then you have the national patents that also can only be brought litigation that regards to the national courts. And so I expect the national courts to be busy during that time. So after the 7 years, again, all opted out patents still stay with the national courts as well as the national patents. So also there is, I guess, a lot of work for the national courts. But in parallel, I also expect the work for the UPC over the years increasing a lot. In particular, when a case law has been developed by the UPC, and from that case law, the users will learn what they can expect from the new court.
Yes. I have one last very important question, maybe the most important. So what is your most important message to our listeners, who mostly come from the US, some come from Germany, some UK, and 80 other countries? So what do you want to convey to our listeners about the Unified Patent Court? What is your most important message?
Yeah, well, this year it's the 50th anniversary of the signature of the European Patent Convention, and the system is in place for about 45 years now, and this system allows users to get a patent granted with respect to almost all European countries. in one-stop shop only. And there were always a lot of efforts to have a similar system also with regard to the enforcement of the patent. So the second column, if I may put it like this, of the European patent system. And and now it is there, not of course covering all the EPC member states, but 17 countries participating in this new system, UPC system, and that is covering 3/4 of the EU GDP. So it is quite an extensive, quite an important part of the European market that can be covered. And I think that is the most important message, that now, at least to a large extent, also enforcement can be a one-stop shop only.
Thank you so much for this great interview and for your patience with me. Thank you very much for being on IP Fridays.
It's always a pleasure, and thank you too.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.